Chapter 22 Parliament. The Parliament is the legislative organ of the Union government. It occupies a preeminent and central position in the Indian democratic political system due to adoption of the parliamentary form of government, also known as Westminster model of government. Article 79 to 122 in Part 5th of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers, and so on of the Parliament. Organization of Parliament. Under the Constitution, the Parliament of India consists of three parts, that is, the President, the Council of State, and the House of the People. In 1954, the Hindi names Rajya Sabha and Lok Sabha were adopted by the Council of States and the House of People respectively. The Rajya Sabha is the upper house, second chamber or house of elders, and the Lok Sabha is the lower house, first chamber or popular house. The former represents the states and union territories of the Indian Union, while the latter represents the people of India as a whole. Though the President of India is not a member of either House of Parliament and does not sit in the Parliament to attend its meetings, he is an integral part of the Parliament. This is because a bill passed by both the Houses of Parliament cannot become a law without the President's assent. He also performs certain functions relating to the proceedings of the Parliament. For example, he summons and prorogues both the houses, dissolves the Lok Sabha, addresses both the houses, issues ordinances when they are not in session, and so on. In this respect, the framers of the Indian Constitution relied on the British pattern rather than the American pattern. In Britain, the Parliament consists of the Crown, King or Queen, the House of Lords, upper house, and the House of Commons, lower house. By contrast, the American president is not an integral part of the legislature. In USA, the legislature, which is known as Congress, consists of the Senate, upper house, and the House of Representatives, lower house. The parliamentary form of government emphasizes on the interdependence between the legislative and executive organs. Hence, we have the president in parliament like the crown in parliament in Britain. The presidential form of government, on the other hand, lays stress on the separation of legislative and executive organs. Hence, the American president is not regarded as a constituent part of the Congress. Composition of the two houses. Composition of Rajya Sabha. The maximum strength of the Rajya Sabha is fixed at 250, out of which 238 are to be the representatives of the states and union territories elected indirectly, and 12 are nominated by the President. At present, the Rajya Sabha has 245 members. Of these, 229 members represent the state, 4 members represent the union territories, and 12 members are nominated by the President. The fourth schedule of the Constitution deals with the allocation of seats in the Rajya Sabha to the states and union territories. Number 1. Representation of state. The representatives of states in the Rajya Sabha are elected by the elected members of the state legislative assemblies. The election is held in accordance with the system of proportional representation by means of the single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of population. Hence, the number of representatives varies from state to state. For example, Uttar Pradesh has 31 members while Tripura has 1 member only. However, in USA, all states are given equal representation in the Senate irrespective of their population. USA has 50 states and the Senate has 100 members, 2 from each state. Number 2. Representation of union territories. The representatives of each union territory in the Rajya Sabha are indirectly elected by members of an electoral college specially constituted for the purpose. This election is also held in accordance with the system of proportional representation by means of the single transferable vote. Out of the 9 union territories, only 3, Delhi, Puducherry, and Jammu and Kashmir, have representations in Rajya Sabha. The populations of other 6 union territories are too small to have any representative in the Rajya Sabha. Number 3. Nominated members. The President nominates 12 members to the Rajya Sabha from people who have special knowledge or practical experience in art, literature, science, and social service. The rationale behind this principle of nomination is to provide eminent persons a place in Rajya Sabha without going through the process of election. It should be noted here that the American Senate has no nominated members. Composition of Lok Sabha. The maximum strength of the Lok Sabha is fixed at 552. Out of this, 530 members are to be representatives of the state, 20 members are to be representatives of the union territories, and 2 members are to be nominated by the president from the Anglo-Indian community. At present, the Lok Sabha has 545 members. Of these, 530 members represent the state, 13 members represent the union territories, and 2 Anglo-Indian members are nominated by the president. Number 1. Representation of a state. The representatives of states in the Lok Sabha are directly elected by the people from the territorial constituencies in the state. The election is based on the principle of universal adult franchise. Every Indian citizen who is above 18 years of age and who is not disqualified under the provision of the Constitution or any law is eligible to vote at such election. The voting age was reduced from 21 to 18 years by the 61st Constitutional Amendment Act of 1988. Number 2. Representation of Union Territories. The Constitution has empowered the Parliament to prescribe the manner of choosing the representatives of the Union Territories in the Lok Sabha. Accordingly, the Parliament has enacted the Union Territories Direct Election to the House of the People Act 1965, by which the members of Lok Sabha from the Union Territories are also chosen by direct election. Number 3. Nominated members. The President can nominate 2 members from the Anglo-Indian community if the community is not adequately represented in the Lok Sabha. Originally, this provision was to operate till 1960 but has been extended till 2020 by the 95th Amendment Act of 2009. System of elections to Lok Sabha. The various aspects related to the system of elections to the Lok Sabha are as follows. Territorial constituencies. For the purpose of holding direct elections to the Lok Sabha, each state is divided into territorial constituencies. In this respect, the Constitution makes the following 2 provisions. Number 1. Each state is allotted a number of seats in Lok Sabha in such a manner that the ratio between that number and its population is the same for all states. This provision does not apply to a state having a population of less than 6 millions. Number 2. Each state is divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In brief, the Constitution ensures that there is uniformity of representation in 2 respects, between the different states and between the different constituencies in the same state. The expression population means the population as ascertained at the preceding census of which the relevant figures have been published. Readjustment after each census. After every census, a readjustment is to be made in allocation of seats in the Lok Sabha to the state and division of each state into territorial constituencies. Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, the Parliament has enacted the Delimitation Commission Act in 1952, 1962, 1972 and 2002 for this purpose. The 42nd Amendment Act of 1976 froze the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment was extended for another 25 years, that is, up to year 2026, by the 84th Amendment Act of 2001, with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in the states on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the number of seats allotted to each state in the Lok Sabha. Reservation of seats for SCs and STs. Though the Constitution has abandoned the system of communal representation, it provides for the reservation of seats for scheduled caste and scheduled tribes in the Lok Sabha on the basis of population ratios. Originally, this reservation was to operate for 10 years, that is up to 1960, but it has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this reservation is to last until 2020. Those seats are reserved for scheduled castes and scheduled tribes. They are elected by all the voters in a constituency without any separate electorate. A member of scheduled caste and scheduled tribe is also not debarred from contesting a general non-reserved seat. The 84th Amendment Act of 2001 provided for refixing of the reserved seats on the basis of the population figures of 1991 census as applied to rationalization of the general seats. Later, the 87th Amendment Act of 2003 provided for the refixing of the reserved seats on the basis of 2001 census and not 1991 census, first past the post system. Though the Constitution has adopted the system of proportional representation in the case of Rajya Sabha, it has not preferred the same system in the case of Lok Sabha. Instead, it has adopted the system of territorial representation, first past the post system, for the election of members to the Lok Sabha. Under territorial representation, every member of the legislature represents a geographical area known as a constituency. From each constituency, only one representative is elected. Hence, such a constituency is known as single member constituency. In this system, a candidate who secures majority of votes is declared elected. This simple majority system of representation does not represent the whole electorate. In other words, it does not secure due representation to minorities, small groups. The system of proportional representation aims at removing the defects of territorial representation. Under this system, all sections of the people get representation in proportion to their number. Even the smallest section of the population gets its due share of representation in the legislature. There are two kinds of proportional representation, namely single transferable vote system and list system. In India, the first kind is adopted for the election of members to the Rajya Sabha and State Legislative Council and for electing the President and the Vice President. Though some members of the Constituent Assembly had advocated the system of proportional representation for the election of members to the Lok Sabha, the Constitution has not adopted the system due to two reasons. Number one, difficulty for the voters to understand the system, which is complicated due to low literacy scale in the country. Number two, unsuitability to the parliamentary government due to the tendency of the system to multiply political parties, leading to instability in government. Additionally, the system of proportional representation has the following demerits. Number one, it is highly expensive. Number two, it does not give any scope for organizing by-elections. Number three, it eliminates intimate contacts between voters and representatives. Number 4. It promotes minority thinking and group interest. Number 5. It increases the significance of party system and decreases that of voters. Duration of two houses. Duration of Rajya Sabha. The Rajya Sabha, first constituted in 1952, is a continuing chamber, that is, it is a permanent body and not subject to dissolution. However, one-third of its members retire every second year. Their seats are filled up by fresh elections and presidential nominations at the beginning of every third year. The retiring members are eligible for re-election and re-nomination any number of times. The Constitution has not fixed the term of office of members of the Rajya Sabha and left it to the Parliament. Accordingly, the Parliament in the Representation of People Act 1951 provided that the term of office of a member of Rajya Sabha shall be 6 years. The Act also empowered the President of India to curtail the term of members chosen in the first Rajya Sabha. In the first batch, it was decided by lottery as to who should retire. Further, the Act also authorized the President to make provisions to govern the order of retirement of the members of the Rajya Sabha. Duration of Lok Sabha. Unlike the Rajya Sabha, the Lok Sabha is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections, after which it automatically dissolves. However, the President is authorized to dissolve the Lok Sabha at any time, even before the completion of 5 years, and this cannot be challenged in a court of law. Further, the term of Lok Sabha can be extended during the period of national emergency be a law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Membership of Parliament. Qualifications. The Constitution lays down the following qualifications for a person to be chosen as a member of Parliament. Number 1. He must be a citizen of India. Number 2. He must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In his oath or affirmation, he swears to bear true faith and allegiance to the Constitution of India and to uphold the sovereignty and integrity of India. Number 3. He must be not less than 30 years of age in the case of Rajya Sabha and not less than 25 years of age in the case of Lok Sabha. Number 4. He must possess other qualifications prescribed by the Parliament. The Parliament has laid down the following additional qualifications in the Representation of People Act 1951. Number 1. He must be registered as an elector for a parliamentary constituency. This is same in the case of both the Rajya Sabha and Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an elector in that particular state was dispensed with in 2003. In 2006, the Supreme Court upheld the constitutional validity of this change. Number 2. He must be a member of a scheduled caste or scheduled tribe in any state or union territory if he wants to contest a seat reserved for them. However, a member of scheduled caste or scheduled tribes can also contest a seat not reserved for them. Disqualifications. Under the Constitution, a person shall be disqualified for being elected a member of Parliament. Number 1. If he holds any office of profit under the union or state government except that of a minister or any other office exempted by Parliament. Number 2. If he is of unsound mind and stands so declared by a court. Number 3. If he is an undischarged insolvent. Number 4. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. Number 5. If he is so disqualified under any law made by Parliament. The Parliament has laid down the following additional disqualifications in the Representation of People Act 1951. Number 1. He must not have been found guilty of certain election offences or corrupt practices in the elections. Number 2. He must not have been convicted for any offences resulting in imprisonment for 2 or more years, but the detention of person under a preventive detention law is not a disqualification. Number 3. He must not have failed to lodge an account of his election expenses within the time. Number 4. He must not have any interest in government contract, work or services. Number 5. He must not be a director or managing agent nor hold a office of profit in a corporation in which the government has at least 25% share. Number 6. He must not have been dismissed from government services for corruption or disloyalty to the state. Number 7. He must not have been convicted for promoting enmity between different groups or for the offense of bribery. Number 8. He must not have been punished for preaching and practicing social crimes such as untouchability, dowry, and sati. On the question whether a member is subject to any of the above disqualifications, the President's decision is final. However, he should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified from being a member of Parliament if he is so disqualified on the ground of defection under the provision of the 10th schedule. A member incurs disqualification under the defection law. Number 1. If he voluntarily gives up the membership of the political party on whose ticket he is elected to that house. Number 2. If he votes or abstains from voting in the house contrary to any direction given by his political party. Number 3. If any independently elected member joins any political party. Number 4. If any nominated member joins any political party after the expiry of 6 months. The question of disqualification under the 10th schedule is decided by the chairman in the case of Rajya Sabha and a speaker in the case of Lok Sabha and not by the President of India. In 1992, The Supreme Court ruled that the decision of the chairman, speaker, in this regard is subject to judicial review. Vacating of seats. In the following cases, a member of parliament vacates his seat. Number 1. Double membership. A person cannot be a member of both houses of parliament at the same time. Thus, the Representation of People Act 1951 provides for the following. If a person is elected to both the houses of parliament, he must intimate within 10 days in which house he desires to serve. In default of such intimation, his seat in Rajya Sabha becomes vacant. B. If a sitting member of one house is also elected to the other house, his seat in the first house becomes vacant. C. If a person is elected to two seats in a house, he should exercise his option for one. Otherwise, both seats become vacant. Similarly, a person cannot be a member of both the parliament and the state legislature at the same time. If a person is elected, his seat in parliament becomes vacant if he does not resign his seat in the state legislature within 14 days. Number 2. Disqualification. If a member of parliament becomes subject to any of the disqualifications specified in the constitution, his seat becomes vacant. Here the list of disqualifications also include the disqualification on the ground of defection under the provision of the 10th schedule of the constitution. Number 3. Resignation. A member may resign his seat by writing to the chairman of Rajya Sabha or speaker of Lok Sabha. As the case may be, the seat falls vacant when the resignation is accepted. However, the chairman, speaker may not accept the resignation if he is satisfied that it is not voluntary or genuine. Number 4. Absence. A house can declare the seat of a member vacant if he is absent from all its meeting for a period of 60 days without its permission. In computing the period of 60 days, no account shall be taken of any period during which the house is prorogued or adjourned for more than 4 consecutive days. Number 5. Other cases. A member has to vacate his seat in the parliament if his election is declared void by the court, if he is expelled by the house, if he is elected to the office of president or vice president, if he is appointed to the office of governor of a state. If a disqualified person is elected to the parliament, the constitution lays down no procedure to declare the election void. This matter is dealt with the Representation of the People Act 1951, which enables the High Court to declare an election void if a disqualified candidate is elected. The aggrieved party can appeal to the Supreme Court against the order of the High Court in this regard. Oath or affirmation. Every member of either House of Parliament, before taking his seat in the House, has to make and subscribe to an oath or affirmation before the President or some person appointed by him for this purpose. In his oath or affirmation, a member of Parliament swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to faithfully discharge the duty upon which he is about to enter. Unless a member takes the oath, he cannot vote and participate in the proceedings of the House and does not become eligible to parliamentary privileges and immunities. A person is liable to a penalty of Rs 500 for each day he sits or votes as a member in a House in the following conditions. Number 1. Before taking and subscribing to the prescribed oath or affirmation. Number 2. When he knows that he is not qualified or that he is disqualified for its membership. Number 3. When he knows that he is prohibited from sitting or voting in the House by virtue of any parliamentary law. Salaries and allowances. Members of either House of Parliament are entitled to receive such salaries and allowances as may be determined by the Parliament, and there is no provision of pension in the Constitution. However, Parliament has provided pension to the members. In 1954, the Parliament enacted the Salaries, Allowances and Pension of Members of Parliament Act. In 2018, the salary of members was increased from Rs 50,000 to Rs 1 lakh per month. The constituency allowances from Rs 45,000 to Rs 70,000 per month, and the office expenses allowances from Rs 45,000 to Rs 60,000 per month. Earlier in 2010, the daily allowances was increased from Rs 1,000 to 2,000 for each day of residence on duty. From 1976, the members are also entitled to a pension on a graduated scale for each 5-year term as members of either House of Parliament. Besides, they are provided with travelling facilities, free accommodation, telephone, vehicle advance, medical facilities, and so on. The salaries and allowances of the Speaker and Deputy Speaker of Lok Sabha and the Chairman and Deputy Chairman of Rajya Sabha are also determined by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. In 1953, the Parliament enacted the Salaries and Allowances of Officers of Parliament Act. Under this Act, Officer of Parliament means any of the following officers, namely the Chairman and Deputy Chairman of Rajya Sabha and the Speaker and the Deputy Speaker of Lok Sabha. In 2018, the Parliament increased the salary of the Chairman of the Rajya Sabha from Rs 1.25 lakh to Rs 4 lakh per month. Similarly, other officers of Parliament, that is the Speaker and Deputy Speaker of Lok Sabha and Deputy Chairman of Rajya Sabha, are entitled to receive a salary per month at the same rates as are payable to the members of Parliament. Further, each office of Parliament other than the Chairman of Rajya Sabha is entitled to receive a daily allowances for each day during the whole of his term at the same rate as is payable to the members of Parliament. Also, each officer of Parliament other than the Chairman of Rajya Sabha is entitled to receive a constituency allowance at the same rate as is payable to the Member of Parliament. According to the same Act, the sumptuary allowance is paid to the Speaker of Lok Sabha at the same rate as is payable to a Cabinet Minister, that is Rs 2000 per month. Likewise, the sumptuary allowance is paid to the Deputy Speaker of Lok Sabha and the Deputy Chairman of Rajya Sabha at the same rate as is payable to a Minister of State, that is Rs 1000 per month. Presiding Officers of Parliament. Each House of Parliament has its own presiding officer. There is a Speaker and a Deputy Speaker for the Lok Sabha and a Chairman and a Deputy Chairman for the Rajya Sabha. A panel of chairpersons for the Lok Sabha and a panel of vice chairpersons for the Rajya Sabha is also appointed. Speaker of Lok Sabha. Election and tenure. The Speaker is elected by the Lok Sabha from amongst its members as soon as may be after its first sitting. Whenever the office of the Speaker falls vacant, the Lok Sabha elect another member to fill the vacancy. The date of election of a Speaker is fixed by the President. Usually the Speaker remains in office during the life of Lok Sabha. However, he has to vacate his office earlier in any of the following three cases. Number 1. If he ceases to be a member of Lok Sabha. Number 2. If he resigns by writing to the Deputy Speaker. And number 3. If he is removed by a resolution passed by a majority of all the then members of Lok Sabha, such a resolution can be moved only after giving 14-day advance notice. When a resolution for the removal of the Speaker is under consideration of the House, he cannot preside at the sitting of the House, though he may be present. However, he can speak and take part in the proceedings of the House at such a time and vote in the first instance, though not in the case of an equality of votes. It should be noted here that whenever the Lok Sabha is dissolved, the Speaker does not vacate his office and continues till the newly elected Lok Sabha meets. Role, powers and functions. The Speaker is the head of the Lok Sabha and is representative. He is the guardian of powers and privileges of the members, the House as a whole and its committee. He is principal spokesman of the House and his decision in all parliamentary matters is final. He is thus much more than merely the presiding officer of Lok Sabha. In these capacities, he is vested with vast, varied and vital responsibilities and enjoys great honor, high dignity and supreme authority within the House. The Speaker of the Lok Sabha derives his power and duties from three sources, that is, the Constitution of India, the Rules of Procedure and Conduct of Business of Lok Sabha and Parliamentary Convention, residuary powers that are unwritten or unspecified in the rules. Altogether, he has the following powers and duties. Number 1. He maintained order and decorum in the House for conducting its business and regulating its proceedings. This is his primary responsibility and he has final power in this regard. Number 2. He is the final interpreter of the provision of the Constitution of India, the Rules of Procedure and Conduct of Business of Lok Sabha and the parliamentary procedures within the House. Number 3. He adjourns the House or suspends the meeting in absence of a quorum. The quorum to constitute a meeting of the House is 1/10 of the total strength of that House. Number 4. He does not vote in the first instance, but he can exercise a casting vote in the case of a tie In other words, only when the House is divided equally on any question, the Speaker is entitled to vote. Such vote is called casting vote and its purpose is to resolve a deadlock. Number 5. He presides over a joint sitting of the two houses of parliament. Such a sitting is summoned by the president to settle a deadlock between the two houses on a bill. Number 6. He can allow a secret sitting of the house at the request of the leader of the house. When the house sits in secret, no stranger can be present in the chamber, lobby, or galleries except with the permission of the speaker. He decides whether a bill is a money bill or not, and his decision on this question is final. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President for assent, the Speaker endorses on the bill his certificate that it is a money bill. Number 8. He decides the question of disqualification of a member of Lok Sabha arising on the ground of defection under the provision of the 10th schedule. In 1992, the Supreme Court ruled that the decision of the Speaker in this regard is subject to judicial review. Number 9. He acts as the ex officio chairman of the Indian Parliamentary Group, which is a link between the Parliament of India and the various parliaments of the world. He also acts as the ex officio chairman of the conferences of presiding officers of legislative bodies in the country. Number 10. He appoints the chairman of all the parliamentary committees of Lok Sabha and supervises their functioning. He himself is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purpose Committee. Independence and impartiality. As the office of Speaker is vested with great prestige, position, and authority, independence and impartiality becomes its sine qua non. The following provisions ensure that the independence and impartiality of the office of the Speaker. Number 1. He is provided with a security of tenure. He can be removed only by a resolution passed by the Lok Sabha by a special majority, that is a majority of all the then members of the House, and not by an ordinary majority, that is a majority of the members present and voting in the House. This motion of removal can be considered and discussed only when it has the support of at least 50 members. Number 2. His salaries and allowances are fixed by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. Number 3. His work and conduct cannot be discussed and criticized in the Lok Sabha except on a substantive motion. Number 4. His powers of regulating procedure or conducting business or maintaining order in the House are not subject to the jurisdiction of any court. Number 5. He cannot vote in the first instance. He can only exercise a casting vote in the event of a tie. This makes the position of Speaker impartial. Number 6. He is given a very high position in the order of precedence. He is placed at 7th rank along with the Chief Justice of India. This means he has a higher rank than all cabinet ministers except the Prime Minister or Deputy Prime Minister. In Britain, the Speaker is strictly a non-party man. There is a convention that the Speaker has to resign from his party and remain politically neutral. This healthy convention is not fully established in India, where the Speaker does not resign from the membership of his party on his election to the exalted office. Deputy Speaker of Lok Sabha. Like the Speaker, the Deputy Speaker is also elected by the Lok Sabha itself from amongst its members. He is elected after the election of the Speaker has taken place. The date of election of the Deputy Speaker is fixed by the Speaker. Whenever the office of the Deputy Speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Lok Sabha. However, he may vacate his office earlier in any of the following 3 cases. Number 1. If he ceases to be a member of Lok Sabha. Number 2. If he resigns by writing to the Speaker. Number 3. If he is removed by a resolution passed by a majority of all the then members of the Lok Sabha. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. He also acts as the Speaker when the latter is absent from the sitting of the House. In both the cases, he assumes all the powers of the Speaker. He also presides over the joint sitting of both the Houses of Parliament in case the Speaker is absent from such a sitting. It should be noted here that the Deputy Speaker is not subordinate to the Speaker. He is directly responsible to the House. The Deputy Speaker has one special privilege, that is, whenever he is appointed as a member of a parliamentary committee, he automatically becomes its chairman. Like the Speaker, the Deputy Speaker, while presiding over the House, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the Deputy Speaker is under consideration of the House, he cannot preside at the sitting of the House, though he may be present. When the Speaker presides over the House, the Deputy Speaker is like any other ordinary member of the House. He can speak in House, participate in its proceedings, and vote on any question before the House. The Deputy Speaker is entitled to a regular salary and allowance fixed by Parliament and charged on the Consolidated Fund of India. Up to the 10th Lok Sabha, both the Speaker and Deputy Speaker were usually from the ruling party. Since the 11th Lok Sabha, there has been a consensus that the Speaker comes from the ruling party, a ruling alliance, and the post of Deputy Speaker goes to the main opposition party. The Speaker and the Deputy Speaker, while assuming their offices, do not make and subscribe any separate oath or affirmation. The institution of Speaker and Deputy Speaker originated in India in 1921 under the provision of the Government of India Act of 1990, Montagu-Chelmsford Reforms. At that time, the Speaker and the Deputy Speaker were called the President and the Deputy President respectively, and the same nomenclature continued till 1947. Before 1921, the Governor General of India used to preside over the meetings of the Central Legislative Council. In 1921, the Frederick White and Sachidanand Sinha were appointed by the Governor General of India as the first Speaker and the first Deputy Speaker, respectively, of the Central Legislative Assembly. In 1925, Vittal Bhai J. Patel became the first Indian and the first elected Speaker of the Central Legislative Assembly. The Government of India Act of 1935 changed the nomenclatures of President and Deputy President of the Central Legislative Assembly to the Speaker and Deputy Speaker respectively. However, the old nomenclature continued till 1947 as the federal part of the 1935 Act was not implemented. G.V. Mavlankar and Anantha Sayanam Iyengar had the distinction of being the first Speaker and the first Deputy Speaker respectively of Lok Sabha. G.V. Mavlankar also held the post of Speaker in the Constituent Assembly, Legislative as well as the Provisional Parliament. He held the post of Speaker of Lok Sabha continuously for 1 decade from 1946 to 56. Panel of Chairperson of Lok Sabha. Under the rules of Lok Sabha, the Speaker nominates from amongst the member a panel of not more than 10 chairpersons. Any of them can preside over the House in the absence of the Speaker or the Deputy Speaker. He has the same powers as the Speaker when so presiding. He holds office until a new panel of chairpersons is nominated. When a member of the panel of chairperson is also not present, any other person, as determined by House, act as the Speaker. It must be emphasized here that a member of the panel of chairpersons cannot preside over the House when the office of the Speaker of Deputy Speaker is vacant. During such time, the Speaker's duties are to be performed by such member of the House as the President may appoint for the purpose. The elections are held as soon as possible to fill the vacant post. Speaker Pro Tem. As provided by the Constitution, the Speaker of the last Lok Sabha vacates his office immediately before the first meeting of the newly elected Lok Sabha. Therefore, the President appoints a member of Lok Sabha as the Speaker Pro Tem. Usually, the senior-most member is selected for this. The President himself administers oath to the Speaker Pro Tem. The Speaker Pro Tem has all the powers of the Speaker. He presides over the first sitting of the newly elected Lok Sabha. His main duty is to administer oath to the new members. He also enables the House to elect the new Speaker. When the new Speaker is elected by the House, the office of the Speaker Pro Tem ceases to exist. Hence, this office is a temporary office existing for a few days. Chairman of Rajya Sabha. The presiding officer of the Rajya Sabha is known as the Chairman. The Vice President of India is the ex officio Chairman of the Rajya Sabha. During any period when the Vice President acts as President or discharges the function of the President, he does not perform the duties of the office of the Chairman of Rajya Sabha. The Chairman of Rajya Sabha can be removed from his office only if he is removed from the office of the Vice President. As a presiding officer, the powers and functions of the chairman in the Rajya Sabha are similar to those of the speaker in the Lok Sabha. However, the speaker has two special powers which are not enjoyed by the chairman. Number 1. The speaker decides whether a bill is money bill or not, and his decision on this question is final. Number 2. The speaker presides over a joint sitting of two houses of parliament. Unlike the speaker, who is a member of house, the chairman is not a member of house. But like the speaker, the chairman also cannot vote in the first instance. He too can cast a vote in the case of an inequality of votes. The Vice President cannot preside over a sitting of Rajya Sabha as its chairman when a resolution for his removal is under consideration. However, he can be present and speak in houses and can take part in its proceedings without voting, even at such a time while the speaker can vote in the first instance when a resolution for his removal is under consideration of the Lok Sabha. As in case of a speaker, the salaries and allowances of the chairman are also fixed by the parliament. They are charged on the consolidated fund of India and thus are not subject to the annual vote of parliament. During any period when the vice president acts as president or discharges the function of the president, he is not entitled to any salary and allowances payable to the chairman of the Rajya Sabha, but he is paid the salary and allowances of the president during such a time. Deputy Chairman of Rajya Sabha. The Deputy Chairman is elected by the Rajya Sabha itself from amongst its members. Whenever the office of Deputy Chairman falls vacant, the Rajya Sabha elects another members to fill the vacancy. The Deputy Chairman vacates his office in any of the following three cases. Number 1. If he ceases to be a member of Rajya Sabha. Number 2. If he resigns by writing to the chairman. Number 3. If he is removed by a resolution passed by a majority of all the then members of Rajya Sabha. Such a resolution can be moved only after giving 14-day advance notice. The Deputy Chairman performs the duties of the Chairman's office when it is vacant or when the Vice President acts as President or discharges the function of the President. He also acts as the Chairman when the latter is absent from the sitting of the House. In both the cases, he has all the powers of the Chairman. It should be emphasized here that the Deputy Chairman is not subordinate to the Chairman. He is directly responsible to the Rajya Sabha. Like the Chairman, the Deputy Chairman, while presiding over the House, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the Deputy Chairman is under consideration of the House, he cannot preside over a sitting of the House, though he may be present. When the chairman presides over the House, the deputy chairman is likely any other ordinary member of the House. He can speak in the House, participate in its proceedings, and vote on any question before the House. Like the chairman, the deputy chairman is also entitled to a regular salary and allowances. They are fixed by Parliament and are charged on the Consolidated Fund of India. Panel of Vice Chairperson of Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from amongst the members a panel of vice chairperson. Any one of them can preside over the House in the absence of the chairman or the deputy chairman. He has the same power as the chairman when so presiding. He holds office until a new panel of vice chairperson is nominated. When a member of the panel of vice chairperson is also not present, any other person as determined by the House act as the chairman. It must be emphasized here that a member of the panel of vice chairperson cannot preside over the House when the office of the chairman or the deputy chairman is vacant during such a time. The chairman's duties are to be performed by such member of the House as the President may appoint for the purpose. The elections are held as soon as possible to fill the vacant post. Secretariat of Parliament. Each House of Parliament has separate secretarial staff of its own, though there can be some posts common to both the houses. Their recruitment and services conditions are regulated by Parliament. The Secretariat of each house is headed by a Secretary General. He is a permanent officer and is appointed by the presiding officer of the House. Leaders in Parliament. Leader of the House. Under the rules of Lok Sabha, the Leader of the House means the Prime Minister. If he is a member of Lok Sabha or a minister who is a member of Lok Sabha and is nominated by the Prime Minister to function as the Leader of the House, there is also a Leader of the House in the Rajya Sabha. He is a minister and a member of Rajya Sabha and is nominated by the Prime Minister to function as such. The leader of the house is either house is an important functionary and exercises direct influence on the conduct of business. He can also nominate a deputy leader of the house. The same functionary in USA is known as the majority leader. Leader of the opposition. In each house of parliament, there is the leader of opposition. The leader of the largest opposition party, having not less than 110 seats of the total strength of the house, is recognized as the leader of the opposition in that house. In a parliamentary system of government, the leader of the opposition has a significant role to play. His main function are to provide a constructive criticism of the policies of the government and to provide an alternative government. Therefore, the leader of opposition in the Lok Sabha and Rajya Sabha were accorded statutory recognition in 1977. They are also entitled to the salary, allowances, and other facilities equivalent to that of a cabinet minister. It was in 1969 that an official leader of the opposition was recognized for the first time. The same functionary in USA is known as the minority leader. The British political system has a unique institution called the shadow cabinet. It is formed by the opposition party to balance the ruling cabinet and to prepare its member for future ministerial offices. In this shadow cabinet, almost every member in the ruling cabinet is shadowed by a corresponding member in the opposition cabinet. This shadow cabinet serves as the alternate cabinet if there is change of government. That is why Ivor Jennings described the leader of opposition as the alternative prime minister. He enjoys the status of a minister and is paid by the government. Whip. Though the offices of the leader of house and the leader of the opposition are not mentioned in the Constitution of India, they are mentioned in the rules of the house and parliamentary status statute respectively. The office of whip, on the other hand, is mentioned neither in the Constitution of India nor in the rules of the house nor in the parliamentary statute. It is based on the conventions of the parliamentary government. Every political party, whether ruling or opposition, has its own whip in the parliament. He is appointed by the political party to serve as an assistant floor leader. He is charged with the responsibility of ensuring the attendance of his party members in large numbers and securing their support in favor of or against a particular issue. He regulates and monitors their behavior in the parliament. The members are supposed to follow the directives given by the whip, otherwise disciplinary action can be taken.